Yeah, welcome to really good session on trusts for you, because this has been asked by a number of people recently, particularly qualified advisors who've got their CMAPs, read a few pages in the book, and they just don't feel that they're experts in trusts. And if you're going to do this properly, you really do need some training. So I'm looking here at trusts and life assurance, which is the key to the whole thing. Now, I've called this Trust and Life Assurance 101. Bit of an American title there for you, but the whole point is that it's kind of like an overview for you of trusts. If you want to do this properly, you've got to get yourself some training. The great exam is known as an RO5, which is done by the CII, and they will look at life assurance in detail for you, and they'll take a look at trusts. But I want to give this a bit of a once over for you to help you out along the way. Now, you're a qualified mortgage advisor and you're giving advice on mortgages and you're arranging a life assurance. At least I hope you are, because you should do that. Now, the two main problems, of course, in arranging life assurance for clients, and if we draw a couple of little pictures over here for you, let's see if this one squeezes into the page. Yeah, that's fine. There's your client. There's your client, quite happy. And you've arranged some life assurance for them, and that's your happy client. Now, it could be a joint policy, single policy, two single people, whatever it is, but you've arranged some life assurance for these good people, or this good person. Now, the two main problems, of course, in that scenario, is that on this person's death, there's going to be a time delay. Now, the whole point behind it is there need to be somebody else who's going to get the money. So let's put the other person in, shall we? Let's put the other little person in there. There we go. There you go. There's the other person who is due to get the money. And the whole point about life assurance, of course, is it pays out on this person's death, goes to this person to either pay off the mortgage or to bring up the family, whatever it is. That's the whole purpose behind it. Now, the two main problems there, of course, is that when the money, when the policy pays out on death, there's a time delay before the money goes to the person. There's a long time delay because it can take a long time. You've got to go through probate, you've got to go through either will or testacy, whatever it is. And the second potential problem is that the proceeds of this policy, because obviously this is full of money, goes into the person's estate and inflates their estate for inheritance tax purposes, and that's not a good thing. So there's a major problem here, really. Now, the whole point behind a trust is it gets rid of these problems. Now, there's a small issue here about creditors, and arguably, if this person owes somebody some money, that person could send in the big boys to try and claim it, and they might claim the policy. Because policies nowadays don't have any value built into them unless it's an endowment or whole of life or something like that. But they've just lost their shine nowadays, haven't they? So there is a protection against creditors as well. Now, the whole point, of course, is of the trust is it allows you to get rid of these problems. It overcomes these problems because it pays money straight to the beneficiary, and it avoids this money going into your estate issue. So these problems of time are all wiped out and inheritance. So that's the main reason why we do trust. So let's take a look at how we go about it. Let's take a look at the parties to a trust first of all, the people involved in the trust. So setting up the trust is pretty simple nowadays. You don't need to have formal documentation, lawyers and people like that. You might want to have a referral system for wills or powers of attorney or something, but setting up a simple trust for life assurance is something that a mortgage advisor can and should do as well. You do it via the Life Office. So you go online, download the forms, or they'll have a page on the web page, or it could be on the proposal form itself if it's a pretty nifty Life Office and they're pretty up to date. It's always good and useful to have the mortgage advisor on hand to organise the paperwork and stuff like that. Sometimes there'll be questions. There's a client trust relationship going on here as well, and you've got to keep that going as well. But also it's useful for referrals because you're going to have other people involved. The person who sets up the trust, the life assured, let's call this person the life assured now. This is the person whose life is assured, will know some people who need to get involved in the trust. And of course, those people are usually friends, family. So it's really good for getting referrals. So let's look at the names and titles. First of all, the life assured, this person here. This person is known legally as the settlor. There you go. I call it the life assured. Sometimes they're now called the donor. Modern life trusts call them the donor as well. That's the person who sets up the trust effectively. Now, he or she will nominate a trustee. Now, the trustee, and we'll put the trustee in here in green over here. Let's put the trustee in, shall we? There you go. There's the trustee. Now let's put them in there for you in red so we know exactly who they are. Now the point here is that we have this person called the trustee. The trustee is the person who gets nominated by the settlor, or the life assured, in order to hold on to the money and pass it on to the beneficiary. So let's just put the last person in here then. Let's put those pens down. Here are beneficiary. There you go. So we've got settlor, trustee, beneficiary. Settlor sets it all up. On death, the trustee receives the money effectively, passes it on to the beneficiary. And that's the way it's done. So let's just take an example of how this works really. And we'll take a look at modern trusts as well. Now, who is the trustee? Well, the trustee is a person. It can be a lawyer firm, but it's usually a person. I mean, I chose my partner's sister. So my sister-in-law, if you like, is my trustee. You can certainly be a trustee as the settlor, and you should be as well. So there should be a number of trustees as well. You can have 2 or 3 if you want to, but you don't want too many of these people. But they should be somebody that you trust, obviously. They should be somebody of a similar age, maybe younger, because you want them to be alive when you die. Now let's just take a look at a football metaphor for you, because I want to take a look at these beneficiaries as well. We've got a little kiddie down there who's a beneficiary. So how does it work? Well, if you imagine a football metaphor analogy for you, where you have a big match at 3 o'clock on Saturday, and the football manager will have a squad of players, say 22 or so players, available to her to choose on Saturday afternoon to play kick-off at 3 p.m. Now, she probably has an idea roughly who she's going to nominate for the team on Saturday, but she's keeping her options open in case of injuries or whatever. Or COVID now, of course, as well. Now, on the day, at just 2:45 on kick-off, she will name her 11 players who will then kick off the match at 3 o'clock. And that's how trusts work, because the settlor, or the life assured, and the trustee, whoever you've appointed, will have a squad of players, a squad of beneficiaries, effectively, which are generically named. The squad, so children, grandchildren, are generic names, aren't they? That's your squad. On the death of the life assured, the trustee then makes the final decision as to who is going to get it from that squad. So it could well be, I name the beneficiaries as my children. So that's your squad. On death, the trustee only sees one child, so pays the money straight to that beneficiary in its entirety. And that's how modern trusts work. So the final decision then about who gets the money is not actually made until the death of the life assured. Now, obviously, this allows the life assured, who's also the trustee, of course, to make amendments to the squad and add people. If they want to, they can do all those good things, because effectively the policy is now owned by the trustees, which happens to be the settlor. So, okay, that's easy peasy, isn't it? Take a look at the types of trust now. Let's get a little bit legal for you. Types of trust that you might come across when dealing with the insurance company. Now, an old type of trust, I'll put these over here for you, is known as the Married Woman's Property Act Trust. Now, the Married Woman's, there you go, Property Act Trust. Now, that's the first one to talk about. Very old. You can tell by the words Married Woman's Property Act, all very sexist and discretionary and all those good things. So it dates back from 19th century law. Now, the whole point behind this particular trust, though, is that it worked, and basically your money went to your wife, because that's the way it was. There's no alternative. and pretty inflexible, pretty unbendable. You couldn't change it. It was set up and it worked really well. Now, they have been replaced by what's known as absolute trusts. The whole point about an absolute trust is that once you set it up, it's absolute. You can't change it. So, of course, the flexibility is not what we want in the modern era, isn't it? Because these things are not what we want for life assurances, really. Now, beyond that were these things called flexible trusts. These were quite the rage back in the 90s. I used to arrange these for clients left, right and centre, flexible trusts. And flexible trusts work really well. They based around this concept, your trustees, your beneficiaries, you could be flexible as to where the money went. But what you did with flexible trusts is, although you had the squad of people available to you, the settlor would always have somebody in mind up front. So, once the trust was set up, he or she would have the squad of people, obviously the grandchildren, children, but they would name people in there. And the problem with that, of course, is it created what's called an interest in possession. And that's legal talk, meaning that there might be an inheritance tax liability at the time. So it could have been a lifetime transfer, were issues caused by that, because you're kind of naming somebody up front. Now this was removed in 2006. The new law came in, which basically made the next type of trust much more flexible and much more popular, known as the discretionary trust. Now, a discretionary trust is the one that we use nowadays. That's the new kid on the block. Well, it's been around for a while. But the discretionary trust gets round this tax problem by having nobody mentioned as specific individuals up front. So basically you have your squad of children, grandchildren, and you leave it until the trustees and the settlor, of course, the trustee, settlor's dead, so you leave it to the trustees to make that decision on death, and that gets round any lifetime transfer inheritance tax problem at all. So that's pretty much all. So you won't see any of those, you won't see those, you won't see many of those nowadays, but you'll be doing lots of those. But what you might do as a mortgage advisor is come across people that have already got these. They've already got some life assurances, and they bring along the documentation. It's an old flexible trust, for example, or it could even be an old Married Women's Property Act trust. In those cases, you might want to talk to your technical people in your network, or contact the life office involved to see what can be done about that. You might want to think about changing it. You're probably better off just leaving it and focusing on the new policy. Which begs the last question really for you. Which policies should you be putting into trust? Which types of policies? Well, essentially all of them should go into trust, predominantly single life policies. Joint life policies are slightly different, because the whole point about a joint life policy is that when one person dies, the other person gets the money automatically anyway. So there's, strictly speaking, no need for a trust, although you could argue that case. Joint life policy, one dies, one gets the money, and everybody's quite happy. Well, they're not happy because they're dead, aren't they? But you know what I'm saying. Most of the time, though, we should be doing single life policies. Single life term assurance I'm talking about here has no real extra cost for replacing a joint life policy. There's maybe a policy fee to add to it. But the cost of two single life policies is broadly the same as a joint life policy when you're talking about term assurance, which is what we do here. So all types of insurance, mortgage protection, level term, family income benefits should all be put into trust. In fact, there should be a reason for not putting a trust has to be specified. So yeah, definitely default into trust. You might find a critical illness policy might be arranged alongside the life cover. You might have critical illness built in, and in that case you want to be looking at the final type of trust here, which we call a split trust. You might have come across that one. A split trust does what it says on the tin. This one is a discretionary trust effectively, but it's split. So if the critical illness benefit is paid out, it goes to the settlor, who's obviously still alive. But if the life assurance element pays out, settlor's dead, goes to the trustee, gets given over to the beneficiaries along the way. So that's known as a split trust. As I mentioned to you, existing trusts might be looked at, but be careful with old stuff that's been done in the past. It's not your role really to try and sort that out. You'll probably want to get it referred on if it's complicated. Maybe talk to the life office. If you're worried about it, get some technical help on this. There's no big deal why you shouldn't do that. But effectively, every single policy should be put into trust. Dead easy nowadays, it simply is. It's a downloadable form, maybe a website from the life insurance company. It's a bit of a faff, I agree with you. Some advisors won't do it because it's a bit of a faff, and you've got to get people in mind. Although you don't need witnesses anymore now, it's all changed. I did mine in trust actually a couple of weeks ago. And previously, I'd have to have witnesses, witnessing signatures and all sorts of things. But nowadays, they don't even have to sign it. You just nominate the trustee, get the wording right. It's all pre-populated. Just send a copy to the Life Office for them to put on file and keep a copy with the client. It's dead easy to do, but make sure you do it because it's the right thing to do. Hey, there's a 101 for you there on life assurances and trusts. Hope that's been useful for you. Bye.